Yes, no, I think they please you.
Yeah, I'm Mr. Chibon. I don't pray for Mr. Lim. We are here to pray for Mr. Hunt for the first, second, and third Christmas.
Execution? Yes, we are here alongside Mr. Bashar for the execution. We are ready.
No, sorry, the ruling was to be delivered on 21st of July after my proceedings, but in my mind I thought that it was delivered today. Secondly, because of the volume of papers, the paperwork to be done, I usually take care of them, but still I think we are within the court hours. So I proceed and deliver the ruling. It's online at the moment. It's in soft copy, I mean.
Koti inaomba msamaha kwa sababu koti hii ilikuwa itoe uamuzi wake mnamo tarehe 21, lakini kwa sababu ya ukubwa wa kesi hii na zile karatasi ambazo zinahusika, koti hii ilibidi uamuzi wake usomwe siku ya leo. Kwa hiyo koti itaendelea kusoma uamuzi wake.
So I begin. Have you said? Now the county government was an issue which in this ruling the fact of the county is one of the county governments in Kenya established under Article 176 of the Constitution of Kenya 2010. In 2016, through an act of the County Assembly known as the Issue County Education Revolving Fund Act 2016, the county established a revolving fund known as the Issue Education Revolving Fund, which in this ruling shall refer to as the fund. PW1 Joel Chelule chaired the fund. He was being deputed by PW3, Susan Keino, while PW2 Louis Jelimo, who was a member of the fund, and PW6 Joel Korir, a director. The first accused, Misha Ron, was the deputy director. The fund was domiciled at the county's Department of Education, Youth Affairs and Sports. The purpose of the fund and how it operated was well summarized in the testimony of its then director, PW6. Its main purpose was to grant loans to students, which would then be recovered from the students. The loan was meant to assist students fund. The loan was meant to assist and all fund needy students to advance their education, mainly in the field of nursing. A committee used to identify the deserving students. They will visit the local colleges whom they will partner with in the program. Under the leadership of the then governor, the third accused person here in Jackson Mandago, it was felt that there was a need to start an overseas fund. They thus started the process of amending the Parent Act that formed the fund so as to extend the program to fund overseas studies, similar to a program run by the neighboring county of Elgeyo Marakwet. A committee involving PW1, the chair of the fund, PW6, the fund's director, the chief assistant in the department, whose case was withdrawn, filed separately and is therefore not subject of this trial, and the first accused, Jerry Mosha Krono, held a meeting at the chief officer boardroom to deliberate on how to extend the funding to cover overseas studies. accused, PW1, PW6, and the first accused, among other officials, traveled to Finland on a further fact-finding mission on the overseas education funding. They visited some colleges there, notorious one being Tampere University, where the third accused signed a memorandum of understanding MOU between the university and the county. Meanwhile, sometime in 2022, the committee initiated the amendment in the Act. The Chief Officer's Office then placed an advertisement calling suitable candidates for interview with a view to joining the program. The Chief Officer then appointed several officers, including the first to run the secretariat. They were to ensure that the program became successful. They were to receive applications, then conduct interviews at a cost of approximately 6,000 to 9,000. The exams were administered both in written and oral form by an agent from Tampere University, Mandago. The draft will be released in the order of performance. The students will then stay at a KTD account headed by the Education Trust, which as a year after referred to as the trust, and will then be issued with an offer letter. On the trust account, some minutes opening the accounts were shown to the members of the revolving fund when some issues cropped up. The minutes had their signatures, but they denied attending the meeting. The witnesses dispatched the denials, however, confirmed that they received some money from the trust for various administrative purposes. PW4 measured officials of the trust. He, however, also denied attending and participating in the elections. PW6 confirmed that all the trustees receiving the money as trustees. He further confirmed that he was elected in absentia, but that he nevertheless took up the position. The trust was taken over by the current county administration after the third accused had left office, and compliant students are still traveling overseas to date. Apart from some administrative expenses, the county paid the monies to the universities, while some parents were refunded. The parents and the victims who appeared as witnesses in court confirmed that apart from the first accused, the second accused was also based at the secretariat at 11th floor KVDA Plaza. Meanwhile, most of the parents who paid the fees or part thereof experienced delays in having their children travel overseas. Demonstrations were held, and in December 2022, it became apparent that the issue was much bigger than had been thought. The new governor thought it was wiser to establish a task force chaired by his deputy, PW6 Engineer John Barorot, to investigate the issue. The county assembly also received and considered a petition from the concerned parents about the operation and legality of the program. Both branches of the county considered the issue and the petition, and among their recommendations was that the issue and petition be forwarded to the investigating authority in Nairobi. Mainly acting on the county assembly's resolution dated the 22nd of March 2023, produced hearing as exhibit number 438, commenced investigation. PW 138 number 235542, Chief Inspector Martin Munena, conducted the investigations and ultimately charged the accused persons hearing with various counts as follows. In count 1, conspiracy to commit a felony contrary to section 393 of the Penal Code. The particulars are that on diverse dates between the 1st of March 2021 and the 12th of September 2022, within Uasin Gishu County, jointly with others not before court, the accused persons herein conspired to steal Kenya shillings 1.1 billion from account number 12859227778, domicile at Kenya Commercial Bank Eldoret, registered under the English Education Trust Fund, meant for overseas university fees for students under the US English County Overseas Education Program. Count number 2, stealing contrary to section 268(2), as read with section 275 of the Penal Code, where it is alleged that the first and second accused, on diverse dates between the month of June 2021 and 12th of September 2022, at the same bank, jointly with others not before court, stole Kenya shillings 56,512,300 from the same account. Count number 3, stealing contrary to section 268(2), as read with section 275 of the Penal Code, where it is alleged that the first accused, on diverse dates between 15th of June 2021 and 5th of September 2021 at the same bank, jointly with others not before court, stole Kenya shillings 26,553,939 from the same account. Count number 4, stealing contrary to section 268(2), as read with section 275 of the Penal Code, where it is alleged that the second accused, on diverse dates between 12th of August 2021 and 12th of September 2022 at the same bank, jointly with others not before court, stole Kenya shillings 4,803,400 from the same account. Count 5, abuse of office contrary to section 101 as read with section 102A of the Penal Code, cap 63 of the laws of Kenya, where the particulars allege that the first accused and second accused, on the 21st of May 2021 at the same bank, jointly with others not before court, being persons employed in the public service, falsely misrepresented that the Issue Overseas Education Trust account was being opened for the Issue County Government, an act which was prejudicial to the County Government of Issue. Count 6, abuse of office contrary to section 101 as read with section 102A of the Penal Code, cap 63 laws of Kenya, where the particular alleged that the third accused, on diverse dates between the 1st of March 2021 and 31st of March 2022 at Eldoret town within Uasin Gishu County, being the governor of Uasin Gishu County, arbitrarily entered into a memorandum of understanding between various universities in Finland and Canada on behalf of Uasin Gishu County Government without a resolution and approval by County Assembly of Uasin Gishu, an act which was prejudicial to the County Government of Uasin Gishu. Count number 7, abuse of office contrary to section 101 as read with section 102A of the Penal Code, cap 63 laws of Kenya, where the particular alleged that the third accused, on diverse dates between 1st March 2021 and 31st March 2022 at Eldoret town within Uasin Gishu County, being the governor of Uasin Gishu County, arbitrarily misrepresented that the county government of Uasin Gishu was offering full scholarship to students to study in Finland and Canada, an act which was prejudicial to the students under the Uasin Gishu Education Trust Program. Count number 8, abuse of office contrary to section 101 as read with section 102A of the Penal Code, cap 3 of the laws of Kenya, where the particulars allege that the third accused, on diverse dates between the 1st of March 2021 and 31st of March 2022 at Eldoret town within Uasin Gishu County, being the governor of Uasin Gishu County, arbitrarily seconded Uasin Gishu County government staff to a private entity named Uasin Gishu Overseas Education Trust, thereby drawing salary from the county government of Uasin Gishu, an act which was prejudicial to the citizens of Uasin Gishu County. Count 9, forgery contrary to sections 345 and 347B2 as read with section 349 of the Penal Code, cap 53 laws of Kenya, against the first and second accused, in the particular that on the 6th of May 2021, at a known place within the Republic of Kenya, the two accused persons jointly with others not before court forged a document, namely a declaration draft dated the 6th of May 2021, in respect of Uasin Gishu Overseas Education Trust, purporting it to be a genuine document signed by Dr. Joel Cheriot Chelule, Dr. Susan Jepkosgei Keino, and Louis Delimo Cheriwot with intent to defraud the Singishu Overseas Education Trust. Finally, count number 9, the same offense of forgery contrary to section 345 and 347D2, as led with section 349 of the Penal Code, Caption 3 laws of Kenya against the first and second accused, with the particulars that on the 23rd of April 2021, at a known place within the Republic of Kenya, the two accused persons jointly with others not before court forged a document, namely a minutes of Wasingishu Overseas Education Trust, purporting them to be the genuine document signed by Dr. Joel Cherot Chelule with intent to defraud Wasingishu Overseas Education Trust. Now the prosecution case briefly. The prosecution called 138 witnesses, mostly being the victims, and produced several documentary exhibits. The prosecution's case and evidence can be summarized as follows. Students and parents consistently testified that they were lured by an official county advertisement. Exhibits number 20 and 26, believing that they were enrolling in a county-backed scholarship program initiated by the then Governor Jackson Mandago, the third accused hearing. Parents recounted the extreme financial sacrifices made to meet the demands of the program, including the emergency sale of ancestral lands, the liquidation of life savings, and the procurement of high-interest bank loans. These funds were remitted through a mix of direct cash deposits at KCB Bank Eldoret and RTGS transfers, with single families paying between Kenya shilling 650,000 and Kenya shilling 1.3 million to the account number 12859222778. Victims testified that they joined the program with the knowledge that it was a full Wasingishu County scholarship program, while others were informed that they will make a one-time payment, whereby once they paid the amount needed, it will cater for the whole academic program. It was thus alleged that there was a blatant misrepresentation by the three accused persons to the said victim. Is there a court orderly here? A policeman? Let me take it again, that paragraph. Simultaneously, students testified to a bait and switch experience where, after paying tuition, they were burdened with some hidden fees for Finnish language pathway courses, only for the scheme to collapse into cancelled admissions and visa rejection because the accused persons had failed to remit their fees to the universities in Finland and Canada. While a limited number of parents testified to receiving partial or full refunds, these were often described as delayed responses to the mounting public outcry and did not compensate for the lost time, the interest on the loans, nor the nugatory educational opportunities. The resulting evidence depicts a situation where the vast majority were left in debt and the students were left stranded without the education they paid for or the full refund of their money. They allege that the whole process of initiating and executing Wasingishu Overseas Education program was not clear and the victims had no full disclosure, but they trusted the process since it was being spearheaded by the third accused person, who at the beginning of the program in 2021 was a sitting governor of Wasingishu County government, hence a person of immense influence. PW1 Dr. Joel Cherot Chelule testified in his capacity as the chairman of the Wasingishu County Education Revolving Fund while producing his appointment letter PW1 informed the court that she had never signed the trust deed, nor had he participated in any activities related to the registration of the said trust. To his surprise, he learned that he was required to respond to a petition filed by aggrieved parents whose children were intended beneficiaries of the program. Consequently, he denied any participation in the program and categorically distanced himself from the trust deed, which is exhibit number 324, and the minutes dated the 23rd April 2021, exhibits 2 and 4, which authorized the opening of bank accounts and the election of signatories. PW1 declared that these documents, which suggested his participation and signature, were forgeries. Furthermore, alongside two other individuals, he prepared an affidavit sworn on 25th January 2023, exhibit number 6, denouncing any knowledge of the trust operations, and formally requested that their names be expunged from the trustee membership. He testified that he never signed the trust deed nor the minutes. In cross-examination, which was rigorous and included a recall, he gave serious contradictory evidence, which seriously dented his credibility as to whether or not he was aware of the trust fund and whether he was an active beneficiary, where his children had been sent abroad through the funds, and whether his travel with the third accused person was well within his knowledge. Okay. And whether he received various payments from the trust fund. PW2 was Lois Jelimo Cheriot Murray, who testified that she is currently the Vihiga County Director of Education, working for the Teacher Service Commission, TSC. She testified that she was appointed as a member of the Uasin Gishu County Education Revolving Fund on the 5th of May 2019, and she produced her appointment letter at exhibit number 11. She noted that her contract expired on 14th of May 2022 and was not renewed. Furthermore, she denied ever signing the trust deed and indicated to the court that the signature appearing on the document was a forgery. She confirmed that at the time her tenure was with the fund ended, the entity was not considering or processing overseas students, thereby distancing herself from the unauthorized operations of the trust. She confirmed that she never signed the trust deed nor the minutes. Her credibility was also seriously impeached during the rigorous examination on why she kept on attending the meetings of the trust and withdrawing allowance even after her term had ended. PW3 Susan Keino, who testified that she is the current vice chairperson of the Uasin Gishu County Education Revolving Fund. She informed the court that she has been out of the country on sabbatical leave since September 2022. She categorically also disowned her purported appointment as a trustee of the Uasin Gishu Overseas Education Trust and further disputed the minutes, exhibit number 2 and 4, which suggested a resolution was passed to open a bank account. She testified that she never attended any such meeting and denied being a signatory to the trust bank account. Along with PW1 and PW2, she provided specimen signatures which, upon forensic examination by PW135, confirmed that she did not sign the declaration of trust, exhibit number 324, or the authorizing minutes. In cross-examination, she ever confirmed that while on sabbatical leave, she was engaged at Laura University in Finland. Laura University in Finland, whose connection was obtained and achieved during an engagement with the overseas funds. PW26 was Engineer John Kibet Barorot, who was the then Deputy Governor and was appointed to chair the task force to deal with the matter. The appointment came via exhibit number 102. The terms of reference included looking at the overseas education program with a view to coming up with long and short-term solutions by December 2022. The task force engaged various stakeholders, including the students, victims, neighboring county of Elgeyo Marakwet, and concluded that the program was a modified version of the Elgeyo Marakwet one. They realized that Elgeyo Marakwet found it difficult to utilize the money paid by their students, because the same was paid into the county coffers, thus converting it into public money. That in the case of Uasin Gishu County, a trust was therefore formed. The trust operated the trust account at KCB Eldoret, where parents will pay between 900,000 and 1,400,000, depending on the course, i.e. whether it was a diploma or a degree, mainly in nursing. There was further a mandatory pathway program that included learning Finnish language, and the amount for the pathway formed part of the payment. The university's representatives from Finland used to travel during the evaluation of the candidates. There was also another program which sent students to study in Canada and was run directly by the trust, since the studies were to be undertaken in English language. The main issue, according to the task force findings, was how to attend the studies before the parents could provide the bank statements that was to be used to procure the visas for the students. The partnership with the county was therefore a simpler way to procure the visas without the burden of parents providing the bank statements. When the parents raised their complaints about the delay in traveling, and despite some students having already traveled, the parents developed a serious mistrust towards the program. According to PW6, the task force had to convince the parents and students that the program was not a scholarship, so as to develop more trust with them. Because the initial account was in Kenyan currency, the task force therefore opened an account in foreign currency, and a financial director was appointed to be in charge of the new account. PW26 confirmed that the accounts are still running to date, and several victims who complied eventually traveled and graduated. The task force published its report with a recommendation. The same was produced herein as exhibit number 103. The witness stated that they have since refunded Kenya shillings 69 million to students who were unable to travel, that the county now owes some parents around Kenya shillings 100 million, that some parents did not pay fully for their children who had traveled, and these children therefore utilized other parents' monies, that the amount wrongly credited to these children was Kenya shillings 66 million, that most of the students who were unable to travel was mainly because the embassies changed the rules midway the process, and as such, they were unable to get visas. PW26 went ahead to further clarify that about 17 million was lost, as the same was paid in a cohort that not all were qualified, that the university, however, refused to refund the amount, as it argued that the same was high. The task force further found that some students did not complete the fees payment, but that the trust nevertheless went ahead to pay for them. PwC further confirmed that some double payments amounting to 92 million was paid in error to some universities in Canada, that these double payments amounted to administrative errors which cannot be accounted for. He therefore recommended a proper audit, because towards the tail end of the task force, the principal trustee turned uncooperative and even denied them access to the KCB account that was being operated by the trust. That the figure in their report approximates the loss or unaccounted for amount at Kenya shillings 8 million. PW36 was Stephen Lell, who was the then county attorney at the time. He confirmed that the third accused one day arrived from Finland with an MOU which he had signed with Tampere University, that he went through it and confirmed that it was well done and signed. He thus gave it the go-ahead. The MOU was produced herein as exhibit number 159. He stated that the MOU was an understanding between the county and Tampere University, including matters of cooperation in areas of education, learning, consultation, school programs, and commercial activities. He stated that after the 2022 general election, he started hearing issues and politics concerning the overseas program, mainly that the money had been misused. According to him, the program was largely successful. Next, we have PW 41, Joseph Turgat, who was the County Executive Committee member, CECM, in charge of education, culture, social services, sports, and gender at the county at the time. He confirmed that his duties included policy formulation for the department and coordination of the department. He ever denied being in charge of the overseas program, that he came to learn about it when some children came to his office at KVDA Plaza 11th floor inquiring about the program, that he then came to know that the program was being run by its chief officer in charge of youth and sports. That the chief officer and PW6, the first accused here in whom he confirmed was PW6 deputy, the second accused, Joshua Lilei, who was the then chief education of the revolving fund, among other officers who have not been charged in this matter, were running the program. That the officers, though working under him, operated independently most of the time. That his chief officer failed to give him a report of the program, despite him calling for the same. That he therefore had to call for the report using letters on the 3rd of August 2022, a second reminder dated 22nd of August 2022, culminating in a show cause letter for insubordination dated the 25th of August 2022. He eventually consulted with PW26, the deputy governor, and agreed that a forensic auditor be engaged. In cross-examination, the witness, however, contradicted himself and confirmed that he was aware of the overseas program and the amendments that upgraded the county revolving fund to cover overseas institutions, that he paid for his son, who is now in a university in Canada, under the same program. Next, we have PW79, Hilary Kiprop, an advocate of the High Court of Kenya, who informed the court that in early March 2021, he attended an overseas education meeting held at Eldoret. He personally knows the second accused person hearing. He informed the court that the second accused approached him and requested him to register for him a trust, that the purpose of the trust was to assist students travel overseas. That the county was to have a standalone account for the transaction so as to separate it from the Public Finance Management Act. That the second accused then introduced him to some members who had earlier been introduced to the meeting as members of the County Education Revolving Fund. He then prepared a trust deed using second accused equipments. He then confirmed that the trustees from the education sector signed the prepared deed, that they included PW1, PW2, 3, 6, the principal trustee, and the first accused. He then proceeded to Nairobi to register the trust. That before the registration, the second accused requested him to amend the objective to enhance the scope. He therefore did the amendment and forwarded the same to Eldoret. The final version was then forwarded to him by a courier. He then attached the identification cards for the proposed trustees as supporting documents before proceeding to register the trust. He forwarded the registered deed back to the second accused via courier. It established the Working Issue Overseas Education Trust and was produced herein as exhibit number 324. Next, we have PW101, John Kipchumba, who was in 2023 working with the Ministry of Education based as RVTTI, where he was the registrar. He stated that as a registrar at the institution, his duties entailed marketing, external linkage, student admission, amongst others. That on the 4th of September 2023, he received a letter from the DCI requesting him to provide them with a report and statement regarding some monies that were paid to the institution from the County Overseas Fund to the institution. The letter dated 28th of August 2023 was produced as exhibit number 401. He responded that the money was not received by the institution. He recorded a statement to that effect, which was also admitted herein as exhibit number 402. He however confirmed that during that period, they provided facilities for interviews of students who were proceeding to overseas for education, that the facilities were provided free of charge, they received a request for use of the facility from the chief officer. Next, we have PW109, Richard Yogo from the county assembly, where he works as a deputy clerk. He informed the court that some of his duties included management of committees, leading clerks at the table, amongst others. He went ahead to inform the court that the county assembly received a petition from a member of the public concerning the Finland scholarship issue. The petition prayed that the assembly listens to their pleas over the scholarship program. That by a resolution dated 1st of December 2022, the assembly formed an ad hoc committee to investigate the issue. The petition was dispatched to various agencies, including the DCI. Through a letter dated 2nd of March 2023, the resolution forwarding the petition to the various agencies for further action. They included the petitioners, the National Assembly, the Senate, the National Employment Authority, IPOA, Office of the Attorney General, and the DPP. Next, we have PW115, Honorable Gilbert Kiptoche Konga, a member of the Assembly, who confirmed that he chaired the ad hoc committee. He confirmed that the former CECM for Sports, Culture, and Education, PW41, was invited but failed to attend the committee. That he instead wrote to the committee, distancing himself from the program. That the then chief officer, the then office holder was also invited, but also failed to honor the invitation to attend the committee. The committee that felt frustrated and made the following observations. One, that the Finland scholarship program was not a scholarship and was detrimental to the parents because the children at Tampere University were not accorded a flexible learning environment for them to earn a living. That the university believed that the students had been granted full scholarship. B, that there was no legal framework in Western Gishu County to manage the entire program, as the assembly was yet to rectify the same. 3, that the management of the program's trust account 1285922778 at KCB Eldoret East Branch was done in a manner that resembles a merry-go-round. That the account has no documents authorizing withdrawals or any transaction at all. That some of the trustees, 4 of them, were locked out completely from the operations of the account. That some of the trustees are therefore requested to be removed completely from the list of trustees. B, the committee therefore requested the executive to act so as to stop the flow of cash into the account. E, that new applications into the overseas program be stopped. F, that students who had paid fees and other incidentals be assisted to travel. G, that the county attorney, PW36, to step aside because of professional negligence for failing to properly advise the county. H, that EACC and DCI to investigate and take appropriate action. I, that any county official who benefited from the funds be suspended immediately. J, that KCB to take disciplinary action against its staff who allowed the trust account to be opened without due diligence on their part. K, that the county executive engage the services of an independent and a reputable auditor to audit the account and report back to the assembly within 30 days. He further informed the court that these recommendations were made on the 28th of February 2023, but that the assembly is yet to see the reports in the assembly. In cross-examination, he confirmed that the committee did not invest the third accused. He further confirmed that there had been no forensic analysis to confirm that the funds were lost. So next we have PW134 Edwin Bett, who was the then county secretary of the county between the years 2019 and 2024. His employment contract was admitted here as exhibit number 509. As a county secretary, he was the secretary to the county executive committee. His main task was to organize the committee's meeting and communicate the resolutions to the CECMs. He confirmed that the Western Gishu Education Program was being run by the Department of Education and Youth Affairs. He confirmed that the new administration formed a task force in December 2022, which was headed by the then Deputy Governor, PW26. That he was also a member of the task force. He further confirmed that the officers who travel abroad were duly cleared to travel upon invitation by one of the universities abroad. That there was further invitation from Laurel University, which caused him to travel which caused him, the county secretary, to travel upon clearance by the PS for devolution. He confirmed in cross-examination that the trust ran the financial aspects of the program, that the trust was, however, not created by the county government. He further confirmed that the program was being run at the department level and that it required no cabinet approval. He further confirmed that transfer of staff to different departments was his role. He confirmed that the law was amended in early 2022 to introduce the overseas program, which was, however, different from the revolving fund, as it was funded by the parents and not the county. Next, we have PW 135, number 240526, Inspector Martin Pitai, who is a qualified forensic document examiner with more than 10 years working experience. He confirmed that on the 12th of August 2023, they received some exhibits that included a question document marked A, marked capital A, which is exhibit number 324. Also marked A2 were minutes of the trust fund produced herein as exhibit number 514. Marked A3 were other minutes of the trust fund produced herein as exhibit number 515. He also received and marked as B1 a non-signature of PW2. The non-signature, I'm sorry, I need a charger. Could we adjourn? So let me go back to the last paragraph. So PW135 was number 240526, Inspector Martin Kitai, who is a qualified forensic document examiner with more than 10 years experience. He confirmed that on the 12th of August 2023, they received some exhibits that included a question document marked A, which is exhibit number 324. Also marked A2 were minutes of the trust fund produced herein as exhibit number 514. Marked A3 were other minutes of the trust fund produced as exhibit number 515. He also received and marked as B1 a non-signature of PW2. The non-signature of PW2 was marked as B2, while B3 was his specimen signature. B5 was the specimen signature of PW2, while BC was the specimen signature of PW3. He was to compare the question signature marked as A with the specimen and non-signatures marked as B. He concluded in his opinion that the signatures in A were not made by either of the authors of the non and specimen signatures in B. He produced his report as exhibit number 517. A minute. In cross-examination, he confirmed that the question documents were certified copies, which were produced from the original. That it was better if he could have used the original documents. He stated that in making the analysis, he considered the natural variations by looking at the signatures, that the reports were verified by a team of experts. Next, we have PW137, Domtila Mayo, who was working at the KCB Eldoret East branch as the manager in the years 2022 and to 2023. She informed the court that as concerns this case, the first accused, PW6, and the chief officer, the principal trustee, went to the bank and requested to open an account. She advised them to avail an introductory letter, national IDs, KRA pins, minutes, declaration of the trust, and the trust deed. That all the documents were supplied except the trust deed. The account opening form was produced as exhibit number 519. She was informed that the trust deed was still being processed at the land's office. They thus requested for a waiver to allow the opening of the account to proceed without the deed. That their chief officer at the headquarters granted the waiver. The email conversation excerpt with the headquarters were produced as exhibit number 523. The account was thus opened and was operated by the three as signatory. It was account number 12859222778, named Wasingishu Overseas Education Trust account. The account received some deposits from various children and parents. That later the DCI commenced investigations on the account. They thus provided the bank documents, the bank statement, and other documents as required by the DCI. That later on, another Euro account was opened as a sister account, and using the same investigation by the DCI, some withdrawals were made from the account, the Euro account that is, including a check of Kenya shilling 6,478,000 signed by the principal trustee and the first accused for visa processing for particular students. The same was made on the 14th of January 2022 and was produced as exhibit number 526. Another withdrawal was for Kenya shillings 11,050,000 done through a SWIFT transfer on the 19th of January 2023 by the same two signatories, remitting the amount to Canada. She spoke to the first accused, who confirmed through a particular letter that he was remitting the money for payment of school fees for particular students at British Columbia University. The check was produced as exhibit number 527. Another check withdrawal dated 27th of January 2023 was made by the same officials and was verified by the branch operations manager for Kenya shillings 1,440,000. Several other withdrawals were done by the three signatories, which, according to me and to my additions, amounted to Kenya shillings 586,633,204.71. In cross-examination, the witness confirmed that the letter came from the county, but not the CECM Finance. That the withdrawals show where the monies were going to. That some of the monies were for visa processing, while others went to pay school fees, mainly at Tampere University. That the monies withdrawn did not use to benefit the trustees. That she did not complete any suspicious transaction throughout and during the operations of the account. That their bank or any of its employees has not been reprimanded by any authority with regard to the trust. That none of the accounts has ever held 1.1 billion throughout their operations. The highest amount in the account was 130 million, which kept on fluctuating depending on the deposits and withdrawals. That as at 25th of August 2022, Kenya shillings 35 million was in the account. That there is no time the first accused came with no supporting documents of the universities and students that the withdrawals was meant for. She therefore confirmed that the first accused had not stolen or misappropriated any of the monies in the account. That indeed, exhibit number 527 was brought to them with a list of 15 students with detailed information of where the checks withdrawal was meant for. That she cannot remember the second accused withdrawing any money from the bank. The final witness that have been important, have not done, I've summarized the victims, was PW 138, number 235542, Chief Inspector Martin Munene, who was the lead investigator, and testified that his inquiry established a conspiracy to steal a sum of Kenya shillings 1.1 billion from account number 12859227778, domicile at Kenya Commercial Bank, Eldoret. He noted that the account was registered through a private trust under the name of Individual Education Trust Fund. He further testified that the amount had been deposited by victims, including students and parents, as fees and other incidental costs, under the expectation that the students will study abroad under the Western Visual County Education Program. The investigator testified that his investigation observed that the victims were under the perception that the program was spearheaded by the Western Visual County government. They gained confidence in the scheme because the third accused, who was the governor at the time, was the pioneer of the program. However, the investigation established that it was a private program initiated for the purpose of stealing money by the accused persons and others who are still at large. He submitted the trust deed, exhibit number 324, for examination to the document examiner via an exhibit memo dated the 12th of August 2023, exhibit number 513, that the investigation revealed that the trust deed was forged. Specifically, the signatures appearing on the trust deed and minutes for PW1, 2, and 3 were forgeries. The investigator also acquired bank statements for account number 12859227778 and the Euro account number 13014222746, which were produced as exhibits number 524 and 525 respectively. These statements confirmed the deposits made by the victims and revealed the cash withdrawal made by the first and second accused persons. He testified that while the third accused advertised the program as a county initiative using county apparatus and employees, it was a private program intended for their own benefit. Further, that the investigation revealed that the accused persons claimed they had paid the Rift Valley Technical Training Institute (RVTTI) a sum of Kenya shillings 200,000 for students' interview venues withdrawn from account number 12859227778. However, investigation supported by letters dated 5th of September 2023, exhibits numbers 403 and 404, established that this amount was never paid to the institution. He further testified that the first and second accused persons withdrew various amounts of cash, which totaled to Kenya shillings 56,512,300, and further each one of them withdrew Kenya shillings 26,563, 26,563,939, and Kenya shillings 4,803,400, respectively, from account number 12859227778, which remains unaccounted for to date. He also testified that the first and second accused persons, with others not before court, also received various cash amounts made for interviews that were never deposited in the various accounts that were formed. He further stated that the entire overseas program had 3 accounts that were run by private individuals, and the 3 accounts were not within Gishu County government accounts, since they were not sanctioned by the CEC finance of the county. He stated that the Auditor General could not audit the accounts since they were not for the county. He produced the appointment letters for accused 1 and 2 as exhibits 605 and 606 respectively, confirming that they were employees of the Gishu County government between 2021 to 2022. Finally, he produced a letter dated 21st July 2023, exhibit 610, confirming that the overseas program was never approved by the Gishu County Cabinet. He testified that the third accused arbitrarily entered into the MOU with various universities without the resolution or approval of the Gishu County Assembly. He further testified that the third accused initially represented the program as a full scholarship to Finland and Canada, only for it to later emerge that all students were required to pay their own fees. The lead investigator further testified that the trust deed, exhibit 324, was prepared by Hilary Kiprop Marimoi, PW 79. That during the recording of his statement, PW 79 stated that after preparing the document, he forwarded it via North-Rift shuttle to Eldoret. The document was subsequently returned to him for witnessing and registration, having purportedly been signed by all the trustees. That crucially, the investigating officer's evidence showed that during the interrogation of PW 29, the witness confirmed that the trustees whose names appeared on the trust deed did not physically appear before him for the signing. Or witnessing process. The IO testified that no official appointment letter existed authorizing Advocate Hilary Marimoi to act for the county, proving that the trust was created by private individuals. This lack of formal instruction, according to him, reveals that the initiative was a private enterprise masquerading as a legitimate county government program. The IO hearing stated that there were 3 accounts which were opened and operated without being sanctioned by the CEC finance, that the investigation did not have the input of the Auditor General. He further confirmed that no public money was involved or used in the program, that further there was any link of any of the monies withdrawn to any personal account of the accused person hearing. That's the summary of the evidence. Next was submissions, which I won't repeat. I believe you have the submissions with you. So allow me not to go through the submissions here. So both sides submitted the prosecution, the accused first, and the prosecution. Now, as correctly submitted by both sides to the trial hearing, at this stage we are at the prima facie case stage, which is a case to answer stage of the trial. The main issue at this stage has been well captured in the learned prosecution counsel submissions, which I adopt as the sole issue for determination at this stage, namely, whether the prosecution, in discharging its burden of proof, had established a prima facie case that requires me to call upon the accused person's hearing to make their defense as required by Section 211 of the Criminal Procedure Code. If no such case is established, then I am to act accordingly under Section 210 of the CPC and acquit the accused person's hearing as per their respective counts. This was held by Lordship Kachiti J, as he then was, of Tanzania High Court in the case of Jonas Mkize versus Republic at page 218 as follows, and I quote, "If it appears to the court that the case is not made out against the accused person sufficiently to require him to make a defense, either in relation to the offense with which he is charged or in relation to any other offense of which, under provisions of section, he is liable to be convicted, he shall dismiss the charge and acquit the accused person." In the case of Anthony Njeri versus Republic, 2006 EKLR, the Court of Appeal of Kenya was surprised by a High Court judge decisions to call upon the appellant to make his defense, even after the judge had expressed himself in a ruling at this stage on a case to answer as follows, and I quote again, "I've considered the evidence before me. The evidence shows that the accused shot the deceased, David Sila Kimuyu, on 18th of July 2002 at Chiromu of University campus within Nairobi area. There is no eyewitness evidence as to how this happened. All witnesses who gave evidence arrived at the scene of crime after the deceased had been shot and had died. This includes the evidence of John Musimi Kamanza, PW2, who testified that he was with the accused but ran away before the accused shot the deceased dead. The relevant evidence on record which attempts to explain the circumstances under which the shooting took place are on the level of hearsay evidence." The Court of Appeal then commented as follows on appeal: "Having expressed himself so conclusively, we find it difficult to understand why the learned judge found it necessary to put the appellant on his defense. Was there a prima facie case to warrant the trial court to call upon the appellant to defend himself? It is a cardinal principle of our law that the onus is on the prosecution to prove his case beyond reasonable doubt, and a prima facie case is not made out if, at the close of prosecution, the case is merely one which, on a full consideration, might possibly be thought sufficient to sustain a conviction." End of quote. So, as submitted by both sides to this trial, the standard of proof as to whether the prosecution has established a prima facie case or not was laid down in the celebrated case of Ramanlal Chambaklal Bhatt versus Republic, 1957 EA 332, where their lordships, Newham Poly, President, Sir Ronald Sinclair, Vice President, and Bacon J.A., as they then were, explained the concept at page 334 as follows, and I quote again, "The onus is on the prosecution to prove his case beyond reasonable doubt, and the prima facie case is not made out if, at the close of the prosecution, the case is merely one which, on full consideration, might possibly be thought sufficient to sustain a conviction. 2. The question whether there is a case to answer cannot depend only on whether there is some evidence, irrespective of credibility or weight sufficient to put the accused on his defense. A mere scintilla of evidence can never be enough, nor can any amount of worthless discredited evidence. It may not be easy to define what is meant by a prima facie case, but at least it must mean one on which a reasonable tribunal, properly directing its mind to the law and the evidence, will convict if no conviction is offered by the defense. So the same court in Ibiro alias Musa versus Republic, 1960 EA, at page 196, revisited with approval the Ramanlal case above on the issue of the prima facie case. The courts in East Africa, including our own courts, have cited these two cases with relish and for a good reason, because they are good law. So, for example, in the case of Republic versus Kennedy Otieno and 6 others, 1998 EKLR, the High Court of Kenya relied on the above cited authorities, gave a simple explanation of what constitutes a prima facie case. The High Court held that it is a case where there is sufficient evidence upon which the court will convict the accused if no explanation is given. This therefore means that, as at the close of the prosecution's case, and where the burden of proof does not shift to the defense, the prosecution should have laid out a case that can convict the accused, assuming that the accused has no defense in rebuttal. Justice Odunga, in the case of the Republic versus Alex Musau Jimmy, 2022 EKLR, held that an accused person should not be put on his defense in the hope that he may prop up or give life to an otherwise hopeless case, or a case that is dead on arrival. Nyakundi J, on his part, in Republic versus Silas Magongo Onzere, alias Frederick Namema, 2017 EKLR, aptly stated that, and I quote again, where, for example, an accused has not been identified or recognized and there is absolutely no evidence, whether direct or circumstantial, linking him to the offense, it will be foolhardy to put him on his defense. There is no magic in finding that there is a case to answer, and a case to answer ought only to be found where the prosecution case on its own may possibly, though not necessarily, succeed. An accused person should not be put on his defense in the hope that he may prop up or give life to an otherwise hopeless case, or a case that is dead on arrival. Defense case is not meant to fill in the gaping gaps in the prosecution's case. It is such that for a prosecution case to convict, it must meet the evidential threshold of proof. Further, and as aforementioned, it is strict law that the standard of proof in criminal cases for purposes of a conviction is beyond reasonable doubt. It is further strict that in a criminal trial, the burden of proof squarely lies upon the prosecution to prove its case. As correctly stated in the case of Peter Mwangi Karuki versus Republic, 2015 EKLR, the burden of proof does not shift and it remains constant throughout the trial. Further, this burden of proof on the prosecution must be discharged without necessarily weighing or capitalizing on the weaknesses of the defense case. In the case of State of Punjab versus Jabir Singh, 1974, 3 SCC 277, the Indian Supreme Court had this to say, and I quote again, a criminal trial is not like a fairy tale wherein one is free to give flight to one's imagination and fantasy. It concerns itself with the question as to whether the accused arraigned at the trial is guilty of the crime with which he is charged. In arriving at the conclusion about guilty of the accused charged with the commission of the crime, the court has to judge the evidence by the yardstick of probabilities, its intrinsic worth, and the animals of witnesses. Every case in the final analysis will have to depend upon its own facts. Justice S. Mutuku in Republic versus Hassan Mohamed Osman, 2013 EKLR, commented as follows, and I quote again, the burden of proving a criminal case lies with the prosecution and never shifts to the accused unless where the law specifically provides the same. Even where the court calls upon an accused person to testify in his defense, it is not so as to prove himself innocent. Courts do so with a view to allowing an accused person to have his day in court and perhaps adduce evidence that may rebut the prosecution's evidence and raise the much valuable doubt Even in cases where the defense of insanity or other statutory defense available to an accused person exists, the accused is only required to prove such defense on a balance of probability and not beyond reasonable doubt. So with that in mind, let me make the determination. Having considered each party's case, I consider the following as the main and sole issue for this court's determination: whether all the essential ingredients or elements of the charge had been proved beyond reasonable doubt as at the close of the prosecution case. I begin with count number 1. On the charge of conspiracy to commit a felony as charged in the first count, the accused argued that the charge could not stand without any evidence of the essential ingredient of common intention and meeting of the minds. The prosecution, on the other hand, argues that a meeting of the mind does not require a formal written agreement or direct communication between the parties. The prosecution, however, relies on the old 1920 English case of Ref versus Maverick, TLR, volume 14, at page 421, where in a charge to corrupt police, the English court held as follows, and I quote, "It has been further suggested on behalf of the appellants that a clear distinction ought to have been drawn between two things which, it was alleged, were sharply opposed. On the one hand, a series of individual conspiracies between Goddard and the one other person in each case, and on the other hand, a general conspiracy to which the parties were Goddard and all other persons. It was argued that these two things were mutually exclusively, and no doubt in particular circumstances they might be. When once it was considered that, however, that therefore persons to conspire, it was not necessary that there should be direct communication between each and all of the conspirators. It became necessary to look at the circumstances to see if that argument of mutual exclusiveness was satisfactory. So I beg to differ with the Land Prosecution Council. Our case law and jurisprudence might have developed further than the old English case. The offense of conspiracy to commit a felony is contained in section 393 of the Penal Code, which provides as follows, and I quote again: "Any person who conspires with another to commit any felony or to do any act in any part of the world, which if done in Kenya will be a felony, and which is an offense under the laws in force in the place where it is proposed to be done, is guilty of a felony and is liable, if no other punishment is provided, to imprisonment for 7 years, or if the greatest of punishment to which a person convicted of the felony in question is liable is less than imprisonment for 7 years, then to that lesser punishment." In the case of Lawrence Gitau Karani versus Republic, the Lady Justice Mary Kasangu stated that the dominant aspect of the offense of conspiracy is that there must be an agreement, a meeting of the mind. On her part, in Anne Wangechi Mugo and 6 others versus Republic, Lady Justice L. Nduguna stated as follows, and I quote again: "As earlier stated, all the appellants herein were charged with the offense of conspiracy to commit an offense of corruption, while the third, fourth, and fifth appellants were charged with abuse of office. The Penal Code and the ASEA do not define the word conspiracy. The Black Law Dictionary, the 9th edition, defines conspiracy as follows: an agreement by two or more persons to commit an unlawful act, coupled with intent to achieve the agreement's motive, and in most cases, action or conduct that furthers the agreement, a combination of an unlawful purpose." In Archibald, writing on criminal pleadings, evidence and practice, he observes, "The offense of conspiracy cannot exist without the agreement, consent, or combination of two or more persons, so long as a design rests in intention only. It is not indictable. There must be an agreement proof of the existence of a conspiracy is generally a matter of inference deduced from certain criminal acts of the parties accused, done in pursuance of an apparent criminal purpose in common between them. The Court of Appeal in Gichanga v. Republic 1993 KLR 143 held that, with respect to the offences of conspiracy, the crucial issue is whether the appellant and his fellow conspirators acted in concert with the intention that the board be induced to part with its money. So, to prove a conspiracy, the prosecution had to establish that the respondents, together with others, agreed by common mind to defraud the complainant. The inference must be made both from the actions of the accused and the evidence tendered in court. See the case of the Republic vs. Anna Tieno, Abdul and others, 2017 EKLR. Further, Harrisburg's Laws of England at volume 25 observes that it is not enough that two or more persons pursue the same unlawful object at the same time or in the same place. It is necessary to show a meeting of the minds, a consensus to effect an unlawful purpose. It requires that a common purpose between them or among the subject parties is proved. Common intention is set out in section 21 of the Penal Code as follows. When two or more persons form a common intention to prosecute an unlawful purpose in conjunction with one another, and in the prosecution of such purpose, an offense is committed of such a nature that its commission was a probable consequence of the prosecution of such purpose, then each of them is deemed to have committed the offense. Applying the above principles to the facts and circumstances of this case, it is my considered view that the prosecution failed to prove that there was a meeting of minds to constitute the offense of a conspiracy to commit a felony. The prosecution did not demonstrate that the accused were acting with another person or with each other with the common intention of stealing 1.1 billion from the trust account herein. So from the facts set out in the case, there is no evidence of an express agreement among the accused persons herein to steal any money from the trust account. The conspiracy can only be proved or disproved from the facts revealed. Firstly, the second and third accused were confirmed not to have been a signatory to the trust account. Secondly, the first accused action aligned with his role as a county-approved initiative, the Wasingishu County Education Revolving Fund Act of 2014, as amended in 2020. Thirdly, PW6 confirmed in court that the trust avoided revenue pitfalls seen in Elgeyo Marakwet, an important fact that PW138, the investigating officer, obviously avoided in his investigation. Further, it's right to note that the third accused signed MOUs publicly, and trustees operated the opened account openly and with approval of the bank itself. Finally, the investigating officer was put to task to explain how he arrived at this figure of 1.1 billion, which he explained that he added the cumulative amounts deposited by the students. This was however contrary to the evidence given by the bank officials, PW137, who operated the account. No such amount existed in the accounts that the accused would have conspired to steal. The task force findings on the amounts also contradicted the amounts stated in the charge. I thus do hereby agree that inflated lost figures while ignoring its own evidence of the task force analysis and flawed forensic errors. which may in this case. So as correctly submitted by the Land Council for the defense, and in applying the case laws cited above, I do find that a prima facie case has not been established with regards to the first and second accused who are charged with the offense of stealing under section 268(1 as read with section 275 of the Penal Code. In these counts, the first and second accused, were charged with the offense of stealing 512,300 from the trust account herein, while in count 3, the first accused was separately charged with stealing 10,820,000. And in count 4, the second accused has been charged with stealing 2,707,000 from the same account. Now, section 268(1 of the Penal Code defines stealing fraudulently and without claim of right, in quotes, fraudulently and without claim of right, takes anything capable of being stolen with intent to permanently deprive of theft, and is liable to imprisonment for 3 years. Thus, for a prima facie case to be established, and in order to sustain a charge of theft, the prosecution must prove several key elements. Firstly, the property in question must be tangible and capable of being stolen. Secondly, the property must belong to another person or entity, or conversion of the property by the accused persons. And finally, the prosecution must establish that the accused persons intended to permanently deprive the owner of the property. This was as per the holding in the case of Weser and 2 others versus the Republic in the Criminal Appeal number 134 of 2023. So whereas money is a tangible property that is capable of being herein belong to the students, I find that the prosecution's case in these counts fails on the other 2 ingredients, and these are fraudulent and dishonest taking or conversion of the funds herein by the accused person, and that by so doing, the accused had a permanent intent to deprive. So key relevant witnesses herein, including the bank officials and the task force chairman, confirmed that the funds that were withdrawn from the account were used for the program. Testify that all funds withdrawn were for operational expenditure. PW6 confirmed in court that the trustees paid unable to demonstrate how he arrived at the impugned figures that he alleges were stolen by the first and second accused, and he admitted that he does do agree that this demonstrates the shoddy and careless investigations by PW138 as they purport to show that the second accused, who is not a signatory to the impugned trust account and was confirmed not to have received any payments from the bank, thus therefore hereby make a finding that no prima facie case has been established in the 3 counts as it relates to the first and second accused person. 6, 7, and 8, abuse of office according to section 101 as well with 102A of the Penal Code. In count 5, the first and second accused were charged with the offense of abuse that the first and second accused on 21st of May 2021 at the same bank, jointly with others not before court, being persons which was prejudicial to the county government was in issue. In count 6, the third accused has been charged with the same offense of abuse of office according to section 101 as well with section 102A of the Penal Code, Cap 53 laws of Kenya, where the particulars allege that the third accused on diverse dates between the 1st of March 2021 and into an MOU between various universities in Finland and Canada on behalf of the Uasin-Gishu County government without any resolution and approval by the County Assembly of Uasin-Gishu. In count 7, the third accused has further been charged with the offense of abuse of office of contrary to section 101 as read with section 102A of the Penal Code, Cap 53 laws of Kenya, where the particulars allege that the third accused on diverse dates between the 1st of March 2021 on 31st of March 2022 at Eldoret Town within Uasin Gishu County, being the governor of Uasin Gishu County, arbitrarily misrepresented that the county government of Uasin Gishu was offering full scholarship to students to study in Finland and Canada, an act which was prejudicial to the students under the Uasin Gishu Education Trust Program. Similarly, in count 8, the third accused had been charged with the offense of abuse of office, contrary to section 101 as read with section 102A of the Penal Code, Cap 63 laws of Kenya, where the particulars alleged that the third accused on diverse dates between 1st March 2021 and 31st of March 2022 at Eldoret Town within Uasin Gishu County, being the governor of Uasin Gishu County, arbitrarily seconded Uasin Gishu County government staff to a private entity, namely the Uasin Gishu Overseas Education Trust, thereby drawing salary from the county government of Uasin Gishu, an act which was prejudicial to the citizens of Uasin Gishu County. Now, section 101, subsection 1 of the Penal Code defines the above offense as follows, and I quote, any person who, being employed in the public service, does or directs to be done, in abuse of the authority of his office, any arbitrary act prejudicial to the rights of another is guilty of a felony. The High Court, in the case of Koros versus the Republic of Criminal Appeal number 32 of 2019, while interpreting the above provisions and the ingredients of the offense of abuse of office, provided that from the wording of section 101 of the Penal Code, 4 elements of the offense emerge. The accused must be an employee in public service. 1. 2. The accused, in abuse of his authority, acts or sanctions an act. Such act or direction to act must be made arbitrarily, and the act must be prejudicial to the rights of another person. It is also important to point out that the offense stated by section 101(1) of the Penal Code is distinct and independent from the one established under section 46 of the Anti-Corruption and Economic Crimes Act. For a conviction to arise under section 101(1) of the Penal Code, the prosecution ought to prove all the 4 elements of the offense. It is not disputed that the appellant was an employee in the civil service at the time when the offense is alleged to have been committed. It is also not disputed. So, as regards the offenses in count 4, counsel for the defense submitted that there is no evidence of a misrepresentation of the account. That PW 79 testified that he received instructions from the second accused and he also testified on oath that the trustees signed the trust deed in his presence. That on the other hand, PW 137 testified that the account domiciled at KCB was opened legally. For the prosecution, it was submitted that there is a clear proof that this is a clear case of abuse of office against the first and second accused persons, that at all material times, the first and second accused were employees of the Uasin Gishu County Government in their capacities as the Deputy Director, County Education Revolving Fund, and the Chief Education Officer of the Revolving Fund, respectively, as evidenced by the appointment letters produced by the IO at Exhibit 605 and 606. That the evidence of PW 138 and various county officials demonstrated that the first and second accused persons utilized their positions and the country's administrative infrastructure to facilitate a private program without any requisite legal framework. This is supported by the fact that there was no official letter from the county government appointing Hilary Marimoi to draft the trust deed, as he was verbally instructed by the second accused, nor was there any cabinet or county assembly approval for the program, as evidenced by Exhibits 606 and 610. The prosecution relied on the precedent in the case of Republic versus Nyanamba and 8 others, 2020 KEMC 10 KLR. So this must be from a lower court, where the court held that a public officer commits an abuse of office where they engage in acts that are prejudicial to the public interest by bypassing statutory, financial, and administrative procedures, that by using the county employees and apparatus apparatus to promote a private enterprise that resulted in the loss of money. The accused persons acted arbitrarily and in total disregard of the law. That this unauthorized use of public office for private benefit, coupled with the disregard for the Public Finance Management Act, constitutes a formidable and a case against the first and second accused. So let me start that. I did start this section of this judgment by citing and quoting Kuros versus Republic, which held that the offense of abuse of office created by Section 101(1) of the Penal Code is distinct and independent from the one established under Section 46 of the Anti-Corruption and Economic Crimes Act. Thus, the authority cited and relied on by the prosecution, and that is the Republic versus Nyanamba and 8 others, does not apply to the offense herein, given that it addresses charges of abuse of office under Section 46 of the Anti-Corruption and Economic Crimes Act, ASECA, mainly by evaluating whether the public officials use the authority improperly to confer benefits. So secondly, I've wondered why the prosecution appears to always rely on the evidence of should be secondary and a summary of the investigation and evidence gathered which must be direct and relevant. Nevertheless, PW 138 was cross-examined and was prejudicial to the program of the victims. It was indeed confirmed by several witnesses hearing, including the chair of the task force, that new foreign accounts were opened that continued to operate under the trust, but they are still in operation to date. So count 6 was on the issue of the MOU signed without approval. On this, the county of 1, 2, 3, the county attorney, the county secretary, and the others confirmed that the MOU signed herein was a good idea for the benefit of the children of Wasingishu County, and none pointed an accusing finger at the third accused person. The issue that popped up thereafter, which related to how the funds were. Thirdly, no proper representative of the county, which ought to be the complainant hearing, demonstrated any prejudice that the county suffered, even remotely. PW6 testified that the MOUs were signed with several universities, which necessitated the amendment of the Wasingishu County Education Act, amendment the Assembly approved. Yes, I do rely in the case of Wanga and another which held that the prosecution having failed to prove, which was followed, and I quote, the prosecution proved to prove that Kenya Medical suffered prejudice, and having failed to produce in evidence the contract awarded to RAM, there was no basis of convicting the second appellant. The prosecution failed to prove its case against the second appellant. So I rely on that authority to similarly find that there was no basis to charge the third accused with the offense of abuse of office on account of the MOUs only, given that there was no evidence tendered to prove that the county suffered any prejudice. As to count number 7, the adverse by the county that the victims herein read and acted on diminished the relevance of this count once the same was produced as an exhibit. The advert produced by the prosecution was clear that the program was not a scholarship. Further to the above, all the victims who testified had to the trust account, meaning that all of them understood that it was a paid program and not a scholarship as alleged. The victim did react or respond to the advert that referred them to the 11th floor KVDA office, which ran the program, and were duly guided on the payments mode. There were further meetings held at Homecraft, among other venues, that desensitized the parents and candidates on the payments mode. Clearly, there cannot be misrepresentation that this was a free scholarship grant by the county. PW 138 was unable to demonstrate misrepresentation or the usage of the word scholarship. PW 26 testified that there was no free education in Finland for non-citizens. He stressed that parents were informed of fee payment. As to count 8, I found no evidence tender to suggest that the third achieved seconded the county staff to the trust hearing. It was unanimous from all the witnesses hearing that the program hearing was being operated at the departmental level, and that even the county secretary was not directly involved with the operation, that the secondment of the staff from the education department was done by the chief officer in the department, who also doubled up as the principal trustee. Any document produced herein purporting any appointment to this office was not forensically examined to prove its authenticity. This count therefore fails for lack of proof. Thus far, no prima facie case established with regards to counts number 5, 6, 7, and 8. Now I go to the last two counts, the forgery contrary to section 345, 347D2, as read with section 349 of the Penal Code. In these counts, the first and second accused were charged with offenses of forgery. It is alleged that on the 6th of May 2021, at a known place within the Republic of Kenya, the two accused persons, jointly with others not before court, forged a document, namely a declaration draft dated by Dr. Joel Cheriot Chelule, Dr. Susan Kosgei Keino, and Lois Delimo Cheriot, with intent to defraud the Issue of the Republic of Kenya. The two accused persons, jointly with others not before court, forged a document, namely a minutes of a issue over the Education Trust, purporting them to be giving documents signed by Dr. Joel, 35 of the Penal Code, as making a false document with intent to defraud. Section 349 imposes liability for such acts. The prosecution must therefore show false making and intent as per section 347. So first of all, it was clear from the evidence that the first accused had no role in the making of the deed and the minutes. No one saw him make the minutes, and I straight away find no evidence linking him to the charges herein, except possibly the fact that he participated in uttering the minutes to the bank official during the opening of the trust account. He was, however, not alone at that time, and that fact alone cannot therefore be used to infer that he forged some signatures and minutes as alleged herein. The forgeries could have well been done by the co-signatories, given that the principal trustee, who was his boss, was present with him during the uttering of the documents. Further, the offense of uttering false document was not brought against him, and given that the offense, though cognate to the offense of forgery, is or lesser than the offense of forgery, and 353 of the Penal Code provide for the same sentence for the two offenses. Therefore, the provisions for convictions of offenses other than those charged as provided for under sections 179 and 191 of the Criminal Procedure Code becomes unavailable against the first accused person here. The first accused. For the second accused person, there is evidence that he participated in the formulation of the trust deed. There is, however, no evidence to prove that he committed any forgery. His handwriting was not examined, and there was therefore no evidence linking him to any forgery theory. I further agree with the learned counsel for the defense that PW 135's report is unreliable as it is based on photocopies. Having stated so, was the reliance on the evidence of the document examiner sufficient? So the accused persons in the submission think otherwise. Yes. The document examiner found that the signatures in the trust deed and the minutes which formulated the trust were not made by the principal trustees, and that's W1, 2, and 3. In fact, they actively denied knowledge of the existence of the trust. Their demeanor as well testifying herein exhibited lack of candor, as there is evidence that they were aware of the existence of the trust and had just demanded they wanted to be removed as trustees. Further, it was confirmed that some of them were active beneficiaries of the trust fund, as they had relatives who traveled through the trust, and one of them actually benefited by joining one of the universities that was involved in the program hearing as a lecturer in Finland. This lack of candor made the court to doubt their credibility, and that is the reason why this court opted to heavily rely on the evidence of PwC, who exhibited immense candor, going as far as admitting his involvement in the transactions hearing. As I stated, there was no eyewitness to the offense. The parties herein agreed that the document which was examined by the expert was not an original, but a photocopy. No explanation, plausible enough, was offered by the prosecution why the originals was not subjected to the forensic examiner. The examiner went into details on how he arrived at his conclusion, and the fact that essentially did not explain his methodologies in the report. No explanation was given by, okay, yes, I'm there. Ideally, and as per the provisions of Section 167 of the Evidence Act, Cap 80 laws of Kenya, all documentary evidence ought to be proved by primary evidence. Section 68 therefore provides instances when secondary evidence could be used. From the evidence as presented at the trial, there is no reason why the document examiner did not use the original documents. Yet it was not confirmed that the originals were not available. Though the examiner considered that there would be some slight but not much variation, in a situation such as this, it is prudent to always submit primary evidence. This court will either not assume that there could be no difference between the original as well as a photocopy. I do believe that the legislature had every reason to indicate that when and where to use secondary evidence. In the case of Republic versus Padmore, 1930, 46 TLR 365, which was relied by the court in the case of Samson Taylor Akute versus Republic 2006 EKLR, the court did state as follows, and I quote, "Let me say a word about handwriting experts. Let everyone be treated with proper respect, but the evidence of a handwriting expert is sometimes misunderstood. A handwriting expert is not a person who tells you this is the handwriting of such and such a man. It is the person who habituated to the examination of handwriting, practiced in the task of making minute examination of handwriting, directs the attention of others to the things which he suggests are similar, that are no more than that. It is role and province." End of quote. So in conclusion, in making the final findings hearing, I believe the accused will now stand up. Accused only. I'm yet to be done. In making the final findings hearing, let me refer to the case of Joan engagement. The prosecution must prove the case against an accused beyond any reasonable doubt. I also wish to adopt the position of the Supreme Court of India in the case of State of Punjab versus Jagir Singh, that, and I quote, "A criminal trial is not like a fairy tale, wherein one is free to give flight to one's imagination and fantasy. It concerns itself with the question as to whether the accused arraigned at the trial is guilty of the crime with which he is charged. In arriving at the conclusion about the guilt of the accused charged with the commission of a crime, the court has to judge the evidence by the yardstick of probabilities, its intrinsic worth, and the animus of witnesses. Every case in the final analysis will have to depend upon its own facts. I find that the prosecution has failed to establish a prima case in any of the charges herein. It shall be of no use to put the accused on their defense, as that shall mean shifting the onus of proving their innocence or otherwise to them. In arriving at these findings, the court does not necessarily make a definite finding that the accused are factually innocent of the offense with which they are charged. It is simply making a finding that the prosecutor has failed to prove their guilt, and they are therefore constitutionally deemed to be innocent. That is what our law provides. While some people may be unhappy with the presumption of innocence, it is a time-tested principles in all jurisdictions which apply democratic principles. And unless we opt to go the dictatorship mob way, we have no option but to enjoy it. So since the Constitution of Kenya prescribes the rule of law as a binding national value, then the law is paramount, and as was appreciated in Dr. Christopher, page 12, and I quote again, the Constitution of the Republic is a reflection of the supreme public interest, and its provision must be upheld by the courts, sometimes even to the annoyance of the public. We have said before, and we will again repeat it, the Kenyan nation has chosen the path of democracy. Our constitution itself talks of what is justifiable in a democratic society. Democracy is often an inefficient and at times a messy system. Dictatorship, on the other hand, might be quite efficient and less messy. In dictatorship, we could simply round up all these persons we suspect to be involved in corruption and economic crime and simply lock them up without much ado. That is not the path Kenya has taken. It has opted for the rule of law, and the rule of law implies due process. The court must stick to that path, even if the public may, in any particular case, want a contrary thing. And even if those who are mighty and powerful might ignore the court's decision. End of quote. Bagmal J. in Crocher versus Crocher, 1972, 1 WLR 425430, stated that, and I quote again, the only justice that can be attained by mortals who are fallible and are not omniscient is justice according to the law. The justice that flows from the application of sure and settled principles to prove or admitted facts. So, in the end, I thus do hereby dismiss all the charges against the accused person pursuant to the provision of Section 210 of the Criminal Procedure Code, and consequently acquit all of them of the offences of conspiracy to commit a felony, stealing, abuse of office, and forgery, contrary to Section 393, 268(1) as read with Section 275, 101 as read with Section 102A, 345 and 347D to all of the Penal Code respectively. So all their cash bills to be returned back to them or to those who paid the fine. Let me drop the judgment first, please. If you fail to date it, then you so that's a minute. Confirm those present. Machare, you are here. Smith still here. Smith. Now, wait for the first accused. For the accused now. Mr. Chebon. Cheboni. So that's the end of it. We can rise up now.
Gabe sa room space ngoli. Sa room space. Mate, mate.
Ulianza kazi nzuri na ukamaliza. Baba, tunasema ni asante kwa hayo yote, kwa jina la Yesu tumeomba na kushukuru.
Today we are happy that the matter has come to conclusion. The verdict to work with us. For political reasons, just because some people think you can destroy programs so that you can destroy other people's political careers. I want to say that the program was a noble program, and I'm proud of that program because as we speak today, Uasin County has more than 350 students in Finland. Yes. And about 100 students in Canada. The most unfortunate thing is that if the program was continuing, by now, probably we would be having more than 2,000 students from our county in those countries. Let me say that the verdict that has been rendered today was to clear us from the allegation that we abused office, that we stole money, which was not the case. I also want to say categorically that I left office when the program was running on the 22nd of August 2022, and by that time, that account that was cited in court had an amount of 108 million in that account. After I left, more than 60, 70 students also still proceeded to travel for overseas studies and also to seek employment opportunities. I'm consciously aware that the parents whose children did travel and their money was spent on other children still need to get their money back.
Yes.
And this verdict affords us the opportunity to now pursue those parents and children who were paid for by the trust using funds that were meant for other children and whose approval was done when I had already left office, that they must take responsibility. They cannot today be enjoying permanent houses that have been built by those children. Some are driving. Some have even achieved their wildest dream of traveling all the way to Finland, a dream they would never have had if the children would not have gone to Finland. I therefore want to urge the beneficiaries who know themselves and who know they benefited from the program and who are supported and are enjoying the benefits of the program, that they should speak to their conscience and refund the money to the trust so that those parents who are suffering out there can get their money. Number 3, the politics of the program now is over.
Yes. Permanent. Yes. Permanent.
We want to urge the county government of Uasin Gishu, because that is a county program, to take responsibility and follow up and make sure that those parents are refunded. Finally, let me thank my legal team wakili Kibet, wakili Limo, wakili Jebon, wakili Kibungei, and all our other legal experts who worked with us in this journey. I also want to thank the people of Uasin Gishu, our supporters, all who are here, who have consistently, for the 4 years, we have had people who have spent their resources and their time to travel to Nakuru to stand with us for the 4 years. I want to thank you and tell you we are on course when it comes to matters developing our county, standing with our people. We shall stand firmly behind the people of Uasin Gishu so that they can get involvement. So we are committed to the cause, and we want to make sure that we succeed as a county. And I want to encourage the young people of our county that we shall continue to work together, even in achieving more than what we can. It is my sincere hope that the county government of Uasin Gishu, led by Governor B, can now reconcile their thoughts and conscience so that they can restart the program and ensure the people of Uasin Gishu are benefiting. This is a program that is well in line with the UDA manifesto of Kasim Aju. And you'll agree with me that other than those children going to work, they have acquired academic qualifications slightly higher than what they would have achieved if they were here in the country. Today they are making a contribution in the global space on matters health. They are making a contribution in terms of remittances to this country. And I want to urge all our young people who benefited from the program, and they know themselves they benefited from the program, that it is in their responsibility and interest to also make sure that that money is refunded, and also support other young people from the county. When the president visited Finland the other day and met the Kenyan community, 80% of those the president met were actually students that went through this program. To demonstrate that what we were doing was actually in line of trying to alleviate the lack of jobs, the lack of opportunities, and reducing the number of youths who are not economically engaged so that their lives can also improve. So I hope the county government will revisit that matter and now make good with the universities that we had relations and the countries. And the governor should have a public apology for politicizing the program, of course escaping and making sure he didn't appear in court, so that our young people can continue the benefit. Otherwise, I don't want to say more than that. And to our supporters, tunasema tuko imara. So, before I finalize, allow let me just ask my counsel here, Chebon, to just say